What's going on? How's everyone doing?
Shout out to Colin. Everybody else who's cool with Colin.
Chunky! I didn't say.
Get your popcorn and your Coca-Cola and relax.
Anyway, tell Colin I'm ready.
What's going on? This is Colin. How's everybody doing? I hope you're having a great day so far. Happy Tuesday. Happy Tuesday. You guys want to watch some court? I want to watch some court. Let's watch some court. All right. I've got a bunch of random stuff tonight. We are going to start with the case from Judge Slaven's docket today, where we have an upset defense attorney. And the upset defense attorney caused the prosecutor to raise his voice a little bit. Yeah, it's fun to watch. Not if you're in the courtroom, though. It's not fun. But for us, it's entertaining. Yeah, for those of you that have watched me for a while, these are my favorite cases. I like it when lawyers go at it. I really do. So that's what we're starting with. Then we have a Jeremy Schuh appearance today. We've got the Bernard Little from Judge Perkins. I've got another Judge Perkins clip where someone got caught driving to court or driving while in court, and Judge made him come in person. So that one was fun. And then we end with might be one of the biggest idiots of the day. He might have the Idiot of the Day award. We'll see when we get there. All right. But that's what we have tonight. Thank you guys so much for joining me. Before I hit that play button, you know what to do. Hit the like and subscribe. Do your jump kick backflips. Let's go.
People versus Anthony Johnson.
Yes, Your Honor, I'm here.
And Ms. Schlussel.
Good morning, Your Honor. Deborah Schlussel on behalf of the defendant, Mr. Anthony Johnson.
And
Your Honor, I know Ms. Manarino met with Ms. Schlussel. I'm not sure what the disposition was, so but I'm here.
Your Honor, the court's memory. We were here with the court on April 24th. At that time, I told the city's council that there was nothing in the police report that did not appear to be any case. And if there was anything showing that my client signed anything or anything was actually deposited, we would like to see it. We were told it would be sent to us. Then we were here on June 24th. We still did not have it 2 months later. Your Honor told the city that if they did not serve us with that documentation by July 3rd, that you would dismiss this matter. We received that material at 2:42 p.m. yesterday. So we are asking that this matter be dismissed with prejudice because we did not get it by July 3rd. It's been months, and I was told by Ms. Manarino that I have no manners because I asserted this to her. So, Your Honor, I may have no manners in her opinion. I think I have pretty good manners, Your Honor. But regardless, I am asking this matter be dismissed with prejudice because the material was not given to us till 2:42 p.m. in an email yesterday.
Your Honor, can I address this, please?
Sure.
Sure. I was not in the breakout room with Ms. Manarino and Ms. Schlussel, and I was not here at the prior court date that Ms. Schlussel was here with regard to that case. My understanding is that it was not July 3rd, that it was July 7th, which I produced it yesterday. However, I only produced it because we had not heard from Ms. Schlussel since the beginning of this case. On February 20, unbeknownst to the court, at the time that this was represented on the record, on February 25th, 2025, this office, the prosecutor's office for the city of Taylor, has a regular pattern and practice of producing discovery immediately to attorneys to get whatever it is they need. So whenever they ask our office, my office, me and Ms. Manarino, for discovery, we immediately, without a court order, provide a copy of the police report and a discovery order to be entered with specific directions and fax number to be sent to the Taylor Police Records Department to obtain whatever it is the police department has with regard to this file. The reason why we set it up that way is because, as this court is aware, 90% of the time, all the attorneys really want to see is the police report and see the narrative on what's going on. And they don't want to go through the process of obtaining videos and all kinds of stuff that's there. And that's why we provide them with the same standard discovery order to obtain whatever it is they want to do. So this was done, and I have an email to Ms. Schlussel on February 25th, 2025, with the police report, which provides what we may or may not have in it, and a court order to obtain whatever it is she wants to do. All right. And then after the last court date, which was June 24th, on.
Yeah, you're right. There is a typo in the title. See, this is usually I'll get a message before it starts, like, "Hey, you gotta fix your title." Yeah, not tonight. You guys are slacking. Thank you, oh boy. I appreciate it.
June 26th, there is an email. Good morning, Ms. Schlussel, forwarding the February 25th email saying, following up on our discovery request. Here's the email that we sent you previously. Here's another copy of the report in the discovery order. What is it that you're looking for, or whatever it is that you need? Then yesterday morning or yesterday afternoon, I sent an email to Ms. Schlussel because I'm following up, and I say, hey, what's going on? Do you have everything? Do you not have everything? I don't know what's going on. No, nothing, no response. All right. So I went through the file again. I talked to my staff and I said, look, we haven't gotten anything. We're more comfortable with the discovery order being entered because a lot of times there's personal identifying information. There's stuff like that the city and everybody is protected with regard to disclosure when there's a discovery order. And I looked through the documents from the bank, from Total Community Credit Union, and I determined, all right, you know what? I'll just forward this over because we have not heard a response from Ms. Schlussel since February.
All right. Oh, I don't like that smirk on Schlussel's face. So they haven't heard from her since February. They sent the generic discovery that they do for every single case, and she's asking for it to be dismissed. I'd be upset too. I'd be upset too if I was Greco. And I don't know how many cases I've seen Greco as the prosecutor of, but I've never seen him upset, ever. So when I was skimming through and I heard him yell, I'm like, oh, this is good. This has to be good. And yeah, I've seen Schlussel being, at the bad end of a couple different conversations. I've seen Judge Simpson yell at her. I've seen a couple different people get mad at her. So yeah, I'm on Team Greco right now. But Shane, I did kind of that exact same thing last week. I think it was 4th of July. I played a video from the week prior when I had to cancel a stream. I played the exact same video with the same thumbnail and everything. And it definitely said Wednesday on it. But it was Wednesday from the previous week. So, yeah, I've done that before. Mary, thank you so much for the super chat. Big Slate fee, thank you. Thank you. I do appreciate it. All right. How is Schlussel going to respond to this? Let's go.
All right, so I did have...
You're on mute, Debbie.
Ms. Schlussel, you are muted.
Your Honor, with regard to all of that.
Grammar School, I am sorry I missed you. I don't know how I did. Thank you so much for the 5 gifted memberships. I appreciate it. Welcome to the 5 new members. Thank you so much. And you had a great stream. You had a great stream today. Glad to catch you live. Yeah, I had to leave that last case though. I was like, nope, I'm getting pissed. I was so angry towards the last. I was like, no, I can't do it. I know a lot of people like that. Yeah, that's where I put my foot down because I start yelling. That's why I don't do family court on my channel. Is I get mad and I start yelling at the people on the screen. And yeah, nobody needs that. But it was a good video though. I'm glad you had it. Not a lot of people play that kind of stuff. So you might have an in right with that kind of content. Okay, we're watching court. Let's go.
Regardless of an email chain asking me things, the email chain really revved up in the last few days. You said on the record everything was to be turned over to me by July 3rd. It was not. And you said you would dismiss this matter if it had not been. I'm sorry, Your Honor. Go ahead.
Well, I just wanted, because I specifically wrote it down. I said plaintiffs to give discovery to defendant on or before 7/3/2025. 7/8/25 motion to compel discovery / to dismiss. So today was the date and time for a motion to compel discovery and or for a dismissal. If you hadn't got, now last time when you were here, there was nothing specific requested to the court, just that you hadn't gotten discovery. So if there was,
Your Honor,
if there was an email that was there, and then if there was something more specific, Mr. Greco is saying that he said there's an order there. If there's something more specific, tell me what the more specific thing is. So
Your Honor, I specifically said on the record last time that on the 24th, we had asked Ms. Manarino, all we have is a 1-paragraph police report. It has no proof of anything. And as far as I'm concerned, my client didn't do anything. If you can produce the checks that you claim were deposited and show my client's signature, we would like to see them. Ms. Manarino told me she would get those to me before the next court date. She had 2 months. Nobody said, oh, but you know what? You have to go back to our email in February and go through this procedure. She said she would get it to me. If she had said, oh, I can't get it to you until you do this, this, and this, I would have done it. She didn't say that. She said, I will get it to you before the next court hearing. She had 2 months. At the last court hearing, we did not have those checks. I put that on the record. Ms. Manarino said on the record that somebody in the office was supposed to provide it, and they didn't. So, Your Honor, I was very specific about what we wanted, which was the documentation of what they claimed in the police report, which we didn't get. Your Honor, they didn't produce it by July 3rd, and I'm asking that this matter be dismissed with prejudice. They didn't comply with what you said. It was not 7/7, it was 7/3, and I did ask for it April 24th. I was assured by Ms. Manarino that it would be forthcoming, and that she would send it to me. And again, on the record, she represented to the court on June 24th that somebody in the office was supposed to send it, and they didn't. So now we're going back and telling me, or the other side is going back and telling me that I should have responded to emails in February, or I should have responded to emails from yesterday when I was in court all day and I had something due by midnight last night. I didn't see their emails till late yesterday after the close of business. But regardless, none of that is relevant. What is relevant is that I asked for these on the 24th of April. I was told they would be forthcoming on the 24th of June. I said what I did not get, which was the
Oh, I forgot about this part. No. Greco, hold on. I don't want you guys to see their email addresses, and I think I had it on the screen for too long. So, but I don't want you to see the email addresses. But Greco's like, I've got receipts. That's what this is. Sorry.
check documentation because my client is accused of depositing false checks or something of that nature. And you told them to get it to me by July 3rd. They didn't get it to me. I already had the 1-paragraph police report, which has nothing. I mean, there's no proof of anything on there. There's no case on there. And as we know, police reports are not exhibits. They're not evidence. So, Your Honor, I'm now to backtrack, for them to backtrack and say, oh, I should have responded to something in February, or I should have done this or this, when I relied on the prosecution's assurance on April 24th, months ago, that it would be sent to me. And then on June 24th, when the representation was made to the court that the person who was supposed to send it didn't do it. Now all of a sudden it's my fault because of something back in February or emails yesterday? Come on now.
Your Honor, if you can see the shared screen, 2 days after the June 24th court date is the email to Ms. Schlussel.
Yeah, and it does state that the order is there. If you want to get permission to sign your name to it,
we'll enter it for her. And get it. Sorry, Judge.
So here's the thing. What I'm looking for is there any prejudice? All right, and I'm going to set this. Obviously, it seems like Ms. Schlussel is indicating, and zealously so, as a good attorney does, that her client is innocent. And so I'm going to set this for a trial. The next trial date that I even have available wouldn't be until probably the end of September. So if you have these checks, you say that the checks came in the email yesterday?
Yeah,
Yes,
sent 'em
I
yesterday.
received them yesterday, but Your Honor,
Sure.
Your
Then
Honor,
there's
you
not
did
going
not.
to be any prejudice to either party, especially to the defendant here, because he has a zealous representation with Ms. Schlussel representing him. They have the discovery that they're going to need for the trial to prepare for it. I'm going to set it up for a pre-trial a week before the trial. So, and if there is anything else, Ms. Schlussel, do I have your? Actually, is there an order in the file?
No, she hasn't given us consent to sign it, so she could get anything that she wants.
So if anything
Your Honor.
else needs to be, is there anything else that needs to be given to either party?
So, Your Honor, I would argue my client has been prejudiced because this case started in February, Your Honor, in February.
I don't know if you caught that. Judge Slaven under his breath is like he's not. No, that didn't happen. Okay, Mary, you were asking what's going on. Real quick update for everyone that came in late and doesn't want to rewind it. Schlussel is saying that the prosecution or the judge should dismiss the case because she hasn't received discovery yet. Greco has said, we sent you the discovery we send, essentially the default discovery we send to every single defense attorney. We send it to you. That's when you read it over and you tell us what else you need. You never responded to that. So how do I know what I'm supposed to send you if you don't respond to what you want? So she's saying, I'm dismiss this. They didn't send me A, B, and C. He's like, you didn't ask for it. I don't know what to tell you. Your client, we're saying your client wrote these bad checks. We have copies of them. We have everything we need. We sent them to you yesterday because you haven't said anything. I don't know what to tell you, but we sent you the what we're going to use in court. And she's like, nope, dismiss it. That's what's going on. Real quick. John Harley, thank you so much for the 5 gifted memberships. I appreciate it. Welcome to the new members. Good to see you, buddy. Good to see you. Another squid for 5 more gifted memberships. Thank you. Welcome to 5 more members. 10 members in total. Another squid. Thank you so much. Very generous of you guys. Thank you. Okay. All right. I'm out of breath now. Let's go.
And we've come to multiple court dates, and Your Honor, this has been months and months and months. It's been half a year. And Your Honor, you did order.
It's not that they waited till the last minute to send. Today's not the day of trial. So Greco, since he didn't hear from her, he sent her the evidence, or not evidence. Well, yeah, the evidence that he plans to use for this case, which is the checks. The defendant is charged with cashing bad checks. So he sent all the details of the checks yesterday because she hasn't said anything. It's like, okay, well, this is what I'm planning on using. You haven't reached out for anything, not discovery or even to, negotiate a plea deal. So this is what we plan to use. That's what happened. I don't know if one day is too little. I have no idea. Maybe that is a little too late. No idea. But, if she doesn't ask for anything, he's still complying with what he's supposed to do. At least that's how I see it. I'm not an attorney, though. Don't listen to me. Oh, yeah, real quick. I did talk to Judge Slaven about this case. I was interested and I had a lot of questions. Not going to tell you. I promised him that our conversation was going to be off the record, but he did want me to say hi to everybody here. So I wanted to say hi and wish you guys he wished me a good stream and wished you guys a good night watching it. I don't really remember how he said it, but that's what he said. Okay, let's go.
Order them to produce everything by the 3rd. There was nothing about I have to sign an order. You ordered them to produce it, and they didn't. So, Your Honor, I think my client has been prejudiced. And now to wait till September, 7 months later, I'm sorry if my math is correct. Yeah, 7 months later. Now it's July. It's 5 months later.
So,
Your Honor, I don't think that is, I don't think that that's fair to my client because he's shown up. And you didn't say anything about, I have to sign an order. You ordered them to produce it.
Ms.
Just
Schlissel
like
could
on
have
April
gotten all
20
this stuff by the first week of
just-
March.
Wait, I'm sorry, I'm talking. I didn't interrupt you. So just like on April 24th, when Ms. Manarino told me she would send it, and just like on June 24th, where she represented to the court that the wrong person didn't send, or the person who's supposed to send it to the wrong person or didn't send it to us. Now all of a sudden I have to sign an order. They never brought that up before. They said they'd get it to me. So now they're relying on this paperwork when you ordered them to send it and they didn't do it. And you did say that if they didn't serve it on me by the 3rd, which they did not do, then this would be dismissed. And they didn't do it.
No, I didn't say I would dismiss it. I said I'd set it for the 8th for a motion to compel discovery / dismissal. I literally have the notation right here on the file.
I love Judge Slaven. He's like, no, I did not say that. Don't tell me I said that. I've got my receipt right here. Greco brought his receipt. Judge Slaven just flashing his receipt. Schlussel, I think you're in trouble. You're outmatched here. Yeah, receipts win. Receipts win fights. They do. Biggin. Well, first off, I'm not going to say hi to Biggin first. Mrs. Biggin, thank you so much for popping over here. I do appreciate it. And now, Biggin, thank you so much for the raid. I do appreciate it. Welcome to all the raiders. We're finishing up with this first case. We have a spicy attorney battle, which we've had fun with. I mean, that's pretty much it. We're going to be jumping everywhere tonight. Got a bunch of random clips. So, yeah, it's going to be a fun night. But Biggin, thank you so much for the raid. I do appreciate it. That is awesome. And real quick, before we go any further, JP Jazz, thank you so much for the 5 gifted memberships. Welcome to the 5 new members. Thank you so much, JP. I do appreciate it. Okay, let's go. I saw that right play button. Oh, yeah. I probably should have looked that up before I made that comment. I have no idea what that term means, but it was funny, so it worked. All right, let's go.
Okay, so that's my motion, Your Honor. I'm moving that this should
I understand that. And I find that there would be no prejudice. With regard to a court date, I have, let's see, is this going to be a bench trial or a jury trial?
So, Your Honor, now that I have it finally, I would like you to set another retrial soon so that maybe we can work this out soon to be fair to my client since he's waited for months.
Sure, you guys, I want you to be able to take a look at it. You said you got it yesterday. So how about we have a pretrial next week or the 22nd, one of the two, 15th or the 22nd.
Whichever one's good for Ms. Schlussel.
Wait, is this actually Biggin 3? I know Biggin was having issues, and I feel like you might have streamed from your son's setup. So is this Biggin or is this Biggin 3? I don't know. Either way, hi to both of you. Thank you so much for hanging out. Yeah, this case is about over, so I don't really care about pausing it now. They're going to talk for about 20 minutes about rescheduling, or you'll see. Legal Fiction, thank you so much for the 20 gifted memberships. Extremely generous of you. Thank you so much. 20 new members. Welcome. Thank you so much, Legal Fiction. All right. Yeah, let's go.
It's fine with me.
Your Honor, the 22nd would be good for me.
All right, so we're going to set this for the 7/22, and that'll be at 8:30. We'll see everybody then. And then as far as the trial date, is that going to be a bench trial or a jury trial?
What's up, little Biggin? I know you're a gamer, and every time I see you on the stream and you're talking about a game, I know what game you're talking about. I was like, I want to hang out with you just once. Let's have a game session. Let's do it. Let's rock out.
Your Honor, I'm not sure at this time. Can we wait to decide that until the 22nd?
All right, not a problem. I was just trying to look at potential dates. So let me.
Yeah, I knew it. I cut out that. They were arguing about what date to put a trial on for about 5 minutes. There's not going to be a trial. They're gonna figure out a plea deal before the next hearing. But yeah. Anyways, that one was a good way to start. Biggin, you were awesome. Thank you so much for the raid. Let's go. We are rocking. I think we're jumping. I think Jeremy Schuh's next. Yep.
We'll call the matter of the state of Michigan versus Jeremy Schuh, 24S00351.
Tiffany Woods for the people. Good morning, Your Honor. Jonathan Sachs for Mr. Schuh.
Good morning, Mr. Stack. Good morning, Mr. Schuh.
Good morning.
All right. We are here today on a pretrial.
That's correct, Your Honor. This is a case I recently was appointed as substitute counsel. Mr. Schuh had, with prior counsel, had litigated a motion to suppress. That's on appeal, on leave to appeal now to the circuit court. So, and I've ordered the transcripts. I'm requesting either an adjournment for those transcripts and for status there, or else to stay pending appeal.
Response?
No, he's not in jail. He's out of jail. He's not in jail. There was one other comment I wanted to say something about. I don't remember what it was. Let's go.
Judge, I'd have no objection to an adjournment.
I'll adjourn this matter to August 12th, 2025 at 9:00 a.m.
Thank you, Your Honor. Your Honor, could I also ask you to take a look at Mr. Schuh's bond conditions? The issue here is they do include drug testing, and the offense has nothing to do with possession or distribution of narcotics. He has shown as positive for marijuana, but he has explained that he uses those for medical purposes. I'd ask, he has come to court. He's very engaged in this case now that he did do the pro per appeal. I expect him not to have any issues coming to court. So I'd ask you to consider just shifting those bond conditions to not including the drug testing.
Response?
Judge, the court's been asking this defendant for a medical marijuana card and a letter of necessity for many, many months now. And many times he's even failed to test when ordered, claiming that he doesn't have a cell phone to test. There was allegedly some stolen marijuana plants that were located in the defendant's truck. So there is some, ties to some sort of marijuana in his case. And so, Judge, we'd object to that request at this time. Thank you.
Thank you. Anything further from the defense?
Just very quickly, that he was not charged with the marijuana found in his car, and there's no direct evidence that that was marijuana that was reported stolen. But otherwise, nothing different. Thank you.
Okay. For all the reasons stated by the prosecution in this case, and for all the reasons that I've stated over the past months as to why I'm not going to grant your request, I'm still not granting that request. Mr. Schuh needs to provide the medical marijuana letter of necessity like he's been requested to do by this court for months. The motion is denied.
Thank you, Your Honor. And just confirming, August 9th was the date?
August the 12th.
August 12th.
And
sorry about that. Thank you very much, Your Honor.
thank you.
Judge, we did receive another report that he is still testing positive and missing numerous tests. I don't know if the court wants to discuss that today.
Haven't missed no test, you're a liar.
Your Honor, could I request, Mr. Schuh, please don't engage unless the court does ask.
He's basically fraudulently presenting evidence to the court. I'm going to call her on it. I understand, though. I appreciate it. I'm sorry.
Mr. Schuh, did you hear me calling your name, sir?
No, I did not, ma'am. What did you say?
Please stop talking.
Okay, I apologize.
So the report I have is from June 26th. Is there a report past that date?
That's the one I received.
All right. I think Mr. Schuh is correct. It looks like he hasn't missed a test since, because I did reduce it down to 1 time per month. He's been testing as he's supposed to, March, April, May, and June. So
I haven't been called yet in July.
Okay, thank you.
Shut up. You just proved that you were right. Don't call the prosecution a liar, though. Don't do that. That's not going to work out well for you, especially when it comes time for them to recommend a sentence to you. That she was incorrect doesn't make her a liar. I'm pretty sure your attorney would have fought that for you, but you spoke up first. But he was right. He was right. You just got to work on how you're right. You can be right and still lose.
All right, we'll see you back here in August, sir.
All right, thank you.
Thank you.
Thank you.
Oh, and now it's over. All right. Now we're gonna jump over to Judge Perkins. I've got the Bernard Little update from today. He was supposed to have a jury trial. He got kicked out of court yesterday. If you guys haven't seen that video, it was hilarious. I posted it with my Mr. Magoo video yesterday. But he walked into court. He was interrupting Judge Perkins. Judge Perkins just said, "Nope, you're out of here," and kicked him out. It was less than 2 minutes from the time he said, "My name is Bernard Little. I'm here by special appearance under duress." And Judge Perkins just like, "Nope, bye," and sent him packing. But that canceled the jury trial today, which was supposed to be today. And but he came back, and I didn't know. I didn't know what to expect. Judge Perkins did not say if the trial was canceled. It was still on the docket as a jury trial for today. I had no idea what was going to happen. Props to Little for actually coming back. But this is it. This is what happened.
Good morning, Mr. Little. All right. Now, here's the deal. When I speak, you don't talk.
Yeah, I mean, I know. Mike goes live right when these things happen. I wait till 8 o'clock to start my show. Otherwise, I wouldn't have content at night. And I like having my show at night. If I do try to not play what other people play. I do. Did you see the Jeremy Schuh or the Judge Slaven content on their channel? I didn't. But I try. But when it's something that I've been following, I'm going to throw it in. So it's still good. It's still good. But I don't know. I don't know. Do you guys want me to skip it? I'll skip it.
Okay. I'm going to give you an opportunity to speak. I'll give you your opportunity to speak, whatever you need to do to put on the record. But when I'm talking, you don't talk, okay? And I'll let you know when I'm ready to hear what you have to say, okay? That's how it's going to work in here. She's here. But let me go off the record now. Ms. Snyder, I have good morning to you. I have Mr. Little here. Now, they canceled the jury trial yesterday not because you were out sick, but first and foremost, we had an issue, Mr. Little and I yesterday, and that resulted in me putting him out of my courtroom. Since then, I had this Mathis speak to Miss Walker, and they canceled the jury. Mr. Little is here. How do you want to proceed with this?
Officer Benson. And I'm gonna go ahead and talk to him.
I would defer to Your Honor. I know I've spoken to Mr. Little before. I don't believe he'd be interested in discussing any offers or anything like that. Although if he'd like to, of course, I'm willing to discuss it with him. I would just ask that we set a. Sorry.
No, he says no.
I would ask that we set a new jury trial date at least 2 weeks out, so I have time to send out subpoenas.
Yes, Mr. Parker.
Let's see the closest time we can have a jury trial this person. Yesterday was another jury trial, and I had I forget the name, but I wanted all the parties to appear for the final pretrial. I'll get that name to you. I meant to mention that to you yesterday as well.
Thank you, Your Honor. If I could ask if Madam Clerk could send it to me via email, that would be best.
Are you still?
Yesterday. Let's take care of Mr. Little first.
The 22nd is your closest. I don't know, you already have some discussion.
Go ahead.
If I'm not I'm not incorrect, today was the trial. You asked me to come in yesterday for like a pre-trial. Today was supposed to be for trial.
Right, but you messed that up.
Well, that was for yesterday. Today is a whole new day. Today, you said a trial for today.
We're not gonna get.
No, I'm trying to understand you.
We're gonna get understanding. You messed that up.
Okay, I get that. I get that.
All right. So that was the pretext for this. So since you messed that up, we have to reset this.
No problem. No
So we
problem.
want to make sure that everybody's on board and is gonna be heard. Now, we'll reset this and I'm gonna get you as quick as I possibly can. Because I understand that you have a right to a speedy trial. What is that, 22nd of this month?
That's a Tuesday.
Then that's the date that you have?
Yes, I have other dates.
All right, now let's do it on the 22nd. We're gonna get it sooner rather than later. All right, let's call this. Step up, Mr. Little, please.
And so, you know, and the statute is provided for the second offense within 3 years.
And now I'm gonna let you make your record today too. We're gonna make it in an orderly fashion. I speak, I'll let you speak, okay?
Gotcha.
City of Detroit versus Bernard Brandon Little. Case numbers SP 1695294, counts 1, 2, and 3. SP 1695296, counts 1 and counts 2. Appearance for the record, please.
For the record, Brandon Little, a live man, dead man. I'm here on arrest, poison, and force.
Snyder.
Alexa Schneider for the people, P80322.
All right. Today is the date and time set for a jury trial, was set for a jury trial for the reasons mentioned. I'll put them on the record. We had, me and Mr. Little and I had a misunderstanding. I think Mr. Little had a misunderstanding. I wasn't misunderstood yesterday. That was the final pre-trial. And because of that incident yesterday, we canceled the jury trial that was set for today. We're going to reset this jury trial for the 22nd of July at 9:30. We're going to also set a final pretrial again, and this, for the record, I want all parties to appear. You don't have to be in person. You can be on Zoom. But for the jury trial, you have to appear. But I just want to make sure that final pretrial date is.
Yeah, apparently. This is has nothing related to this case. Just because you said, is a dead man ever brought to trial? There was the family of a victim I don't remember. I don't remember if it was murder or what kind of homicide it was, but someone passed away, and during the sentencing, the family had an AI rendition of the deceased speak, as you know, like during the victim impact statement segment. And the judge let it happen. I just read it. I didn't see it. I read the story. Yeah, that was wild. So yeah, so that happened. It was weird.
Set so that all the officers, that we know that the officers are ready to proceed, we know the city is ready to proceed, and we know you're ready to proceed, which I believe you're going to be. I know you're going to be here ready to proceed. So let's make that final pretrial on the 21st, and then have a jury trial on the 22nd. All parties need to be here on the 22nd in person. So let me get this correct. All parties need to be here on the final pretrial. They do not have to be in person. They can be on Zoom. But for the 22nd jury trial, all parties need to appear. Now, there's going to be an exchange of jury instructions. You need to get with the city on that, and you may want to talk to the city before you leave on how you want your jury instructions. And if there's an issue with jury instructions, then we'll discuss that on the final pretrial. But maybe you need to get with the city before you leave. So I got a pamphlet on it. All right, so that you guys can establish that we can come to an agreement on the jury instructions. At this time, I'm going to let you make your record.
Speak up. For matter of record, I'm just here under duress. My name is Bernard Brandon Little. Forced to come here. I have no desire to be here. I'm alive as a man. I should be here for all caps, which is business. I'm not here for business. That capacity.
Is that your record? Okay. All right. Anything further, Ms. Snyder?
This was supposed to be the jury trial date, so that I think that's what he's trying to say with the officers not being there. For the final pretrial, were they? I think they were there yesterday. The officers were there yesterday when he got kicked out of court. I don't know.
Where did she go? There's nothing further. That's how we'll proceed. Final pretrial, the 21st at 8:30, and the jury trial on the 22nd at 9:30. All right. All right. Now, do you want to speak with the city? Make sure that.
I have no desire to.
Okay. Very well. Best of luck to you, Mr. Little. Have a very good rest of your day.
The same.
Thank you.
All right. The 22nd, he's back. He's back. We'll see if that happens. We're going to stay in Judge Perkins' court for the next one. We have a guy that was driving while he was on Zoom, and then he lied to Judge Perkins. Now, I want you. Hold on. I'm gonna do this now before I forget. I'm gonna change it. Pay close attention. So I watched this a couple times. The first time I watched it, I was like, that guy's not driving. His phone is shaking. He's not holding, like, just the way he was holding his phone, it was shaking. But I couldn't see anything moving in the background. So it kind of looked like he was driving, but when you stare at the background, I didn't see anything moving. And then the second time I watched it, I'm like, okay, I guess it is kind of moving. Let me know what you guys think. But I will warn you, there is no end to this. Judge Perkins put himself on mute at the end of his docket when he was calling this case back up. He didn't unmute himself. We don't have the end. We don't know exactly what happened. Judge does say on the record what he's going to do, though. We just don't have, the end of, yeah, you'll see. You'll see. Okay. This one's fun. Let's go.
Caution here.
Yes, Your Honor. Good morning, Your Honor.
Morning. Did I get the pronunciation correct, sir?
It was close. Yes.
Well, let me get the correct pronunciation.
The correct pronunciation.
Okay, never mind. Third time I watched it, he's definitely driving. There's things moving in his background. I don't know why I thought maybe he wasn't driving. Oh, he is. Absolutely.
It's Ghosted. As in ghost, but with the N. Yes.
Ghosted. Okay. Good morning to you.
Good morning.
You can't drive on Zoom, sir.
You're not driving, are you?
No, I'm parked on the side of the road.
I don't know.
I'm in my car, yes. I'm in my car,
The car
yes.
is moving. The car is definitely moving.
So I don't know if you're telling the truth, sir. All right, because I don't believe you, and I'm putting you out of the courtroom.
1 second. Let me.
No, it's not 1 second. Yes.
All right, this is massively broken up. He he passed him and called him back about 10 times. So there's going to be a lot of fade in, fade outs. It's the best I could do. There's some segments that are only 5 seconds long, but I wanted you to get everything that happens.
All right, Mr. Golson, you've lost your privileges to come on Zoom. You might as well just drive on down to the courtroom now, okay?
I'm parked on the side of the road.
No, I'm not gonna go over it with you again. You lied to me. You've lost your privileges to be on Zoom. Come on down. You're coming in person now.
Okay, Your Honor. So when can I come in?
Now. I don't think you understand what's going on. There's the liar. You've already set yourself up to be a liar. You know that?
Sir, you didn't give me a chance.
I gave you a chance. You lied to me.
No, I did not.
Okay, now you're lying again.
Sir,
I don't need to hear you. No. All right. Let's let Ms. Snyder go back and speak to Mr. Garb. This is the city. All right, let me say this. This young man is driving in court. Somebody.
Oh, that's Mr. I didn't see him sitting there.
Yeah, because the reason why he's driving in court, and when I asked him, is he driving? He lies to me and says no. And I see him. Everybody sees him looking up at the road. The stuff is moving in the background. So that's why he's here in person now. And he continues to lie because he just told me again that he wasn't driving again.
Okay. Was he consistent he was a passenger?
No, he was driving.
Okay.
He was driving. There's no ands or buts about that. And he's going to continue to sit here and perpetrate that lie in front of me again. That's why he wants to speak and explain himself. But I don't want to hear.
Okay, sounds good. Judge, what I'm going to do is run to the city prosecutor's office on both these cases. I'm also here on David Long.
And all the officers are here.
They're here on all of them. That's what I thought. Okay, all right, I'll be right back.
Very well. That's the matter. Counselor, are you ready on anyone?
As soon as my client fills out this form, ready on Mr. Costa.
Yeah, I don't think I know what I'm gonna do with him. What's gonna be the resolution if you have any on Mr.
Oh, sure, it's a disobeyed police officer, delayed 3 months, plead guilty.
Yeah, we might extend that more than 3 months.
Okay.
I don't, he's already showed me what type of character he has, and I guess I am pleading to disobey a police officer. That further validates what I've already seen.
Judge, do we have a phone number for Mr. Long? I never got an appointment.
All right, this is the best part. So he was given a defense attorney, which is the guy you heard speaking. He was given a defense attorney for this, who was there in person with him. He's not there right now. He walked out of the room to have a private discussion with someone else on the Zoom call. And this is when this guy decides to try to talk to Judge Perkins. Not a good idea.
It seemed like that was fun.
Really important.
Yeah. Mouse pulling all strings.
Oh, okay, yeah, that's more important. Yeah, I get that.
Your Honor?
Yes.
Do you mind if I have a word with you?
You want to wait till your attorney comes back?
I just want to talk to you about what happened in the morning.
What is it to talk about?
I'm sorry that you took the wrong picture of me, but I'm not like that, sir.
No, listen. Listen. You are like that.
No, I'm born in a religious family, and
no, I don't want to hear about that.
Okay.
You were asked a very simple question, which was going to elicit a very simple response. You chose to give the response that you chose to give.
I did right. No,
right?
I did not lie. Yes.
You did not lie again.
Because me, I live.
Were you driving or not?
No, sir.
You weren't driving. Ms. Bradfield.
I live with my dad. And we both work in the state.
Yes, Your Honor.
instead of taking both cars back and forth, you park one in the safe, and then come together in one car. So it was safe to use. That's all I have to use the one driving. I was a passenger.
Let's roll back the, you were on the driver's side of the car, sir. It's on video. You want to roll back the video? Or are you going to continue to sit here and tell me the same thing? I'm not the only one that saw it. Are you going to continue to do that? Everything is recorded. Everything is on video. So are you going to continue to say that?
No.
So are you going to tell me the truth now?
Yeah.
And so all of that religious stuff that you're talking about, you must not believe it yourself. So don't bring that religious stuff into my courtroom and you sit here and lie on yourself. I'm not giving him a deal. He's going to plead as charged. It's going to be a 12-month delay, and you're going to get the maximum amount of fine. Because you continue to sit here and lie in my face. And you're going to use your religion as a way to perpetrate that lie. There you go, Ms. Gann.
I just need to speak to the prosecutor.
She's been in there all day, I guess.
I go back and talk to her. I'll be right back.
Can't believe that. Starting off, I'm coming from a religious family, but you sit there and lie and continue to lie.
Yeah, that's it. That's it. Like I said, when his attorney came back, so Judge Perkins had a personal conversation with somebody. Like someone came in to say hi to him, and he muted him. He said like, "Hold on, I'm gonna mute the record," and he muted, and then you could tell that he was talking, not to the person that he muted for, but to them. And I didn't get the rest of it. Now, yeah, I mean that's gonna be my story. I tried to find it. I skimmed it, and that's what I believe happened. So we're just gonna keep it at that. Yeah, he did. He did eventually say, well, he didn't. He never admitted to driving. Judge Perkins said, "Are you going to continue to lie to me?" And he finally said, no. I don't know if he ever said yes, I was driving, but I think he admitted it in his own way. Because Judge said, "Do we record everything. We can bring back the video. We can watch you driving. Do you want me to do that?" And that's when he said no. So yeah. But yeah, I apologize for not having the absolute ending of that. But I don't know. Judge Perkins just kind of concluded it for us. All right, let's move on. I think now we go to next Judge Collier. Yep.
DeMonte.
This is the guy I told you from the intro. This might be the biggest. This guy might win the award for the biggest idiot of the day. And he has an attorney. Yeah, you have to watch this to believe this. This blows my mind. This blows my mind how this happened. I really like this judge. He handled this perfectly, but man. Okay, let's go.
Hadex. Mr. Hadex, how you doing, sir? Doing well.
Judge, this is a case that we had filed a.
I do make mighty claims. Let me reclaim that. This is the biggest idiot I've seen today. Okay, and I've seen Bernard Little. We just saw that guy driving in court in line to Judge Perkins. We saw Jeremy Schuh. I mean, and this is I will put him up for the award for the biggest idiot of the day. That's this guy.
Motion to compel the state stipulated and agreed to. And we brought him back today to kind of keep the court aware of where we're at. The case agent for the sheriff's office on this case is working with the authorities in Georgia to get the paperwork, but as of today, it is not, we've not actually received the documents. So all I can tell the court is it's a work in progress right now. And as soon as we get those documents, obviously I'll meet with Mr. Hadex and we'll go over the substance of it at the time. So I think it'd be appropriate to put Mr. Hadex on the 8/12 pretrial docket, which is our next available pretrial docket, so we can keep the court abreast of where we're at.
All right, Your Honor. Yes, sir. May I speak? Sure. So,
Mr. Hadex, you can certainly speak to the court, but I would caution you, as I have before, that everything in here is recorded, and I would advise you not to speak to the facts or the evidence related to your case.
I mean, but that's the most important part. Okay. So we're recording this proceeding. The prosecutor sitting down right behind you. I think Mr. Hill is an experienced and talented trial lawyer. Probably don't want to talk about the facts of your case. If you want to address the discovery issues or any other issues, but.
Yeah, I want to discuss the discovery issue.
Okay.
So I have my discovery, my full discovery with me. I done had it since August 24th. And it was submitted to the clerk of courts I had it since April 24th. It was submitted April 11th. And I have a lot of issues with my discovery due to the fact that it don't talk about me whatsoever. And a lot of the evidence in there has nothing to do with me. So I haven't been able to speak with Mr. Hill. He's supposed to come speak with me a couple of different times, but it ended up never happening. And this motion that he filed that's supposed to be with Georgia, I don't understand the relevance to it at all, because like he stated last time, he is correct. When they came and arrested me, GBI and DOC, they definitely searched my house, but they never came out of my house with anything. I requested the body cam footage in March when I first spoke with Mr. Hill, because a phone that was illegally searched and seized, I requested it. And then it came back up again in April, where I told Mr. Hill about it April 24th, why I wanted the body cam footage. But now, after going over my after going over my discovery, the body cam footage is irrelevant now because it's bigger than a legal search and seize. Now that's not what I'm after no more. Now it was evidence that was planted on me, falsified documents that was made against me with this phone, and it proves it because it's in my paperwork. And me and Mr. Hill looked at this subpoena June 17th, 2 p.m. when he came to visit me, and we went over all my evidence. And the subpoena date for the phone, where AT&T stated that I was a customer since November 1st, 2024. Like I told Mr. Hill, that's impossible, Your Honor. I just sat in prison from December 13th, 2017 to November 7th, 2024. I could not have purchased a contract phone in my name.
In December 2024?
And November, I went to prison December 13th, 2017, and I sat from December 13th, 2017 to November 7th, 2024. The subpoena results state that the phone was purchased November 1st, 2024. That's impossible. I was still sitting in the correctional institution. Another thing that's wrong, the phone is in custody. It is in Gulf County custody. The phone is not through AT&T. It's through Boost Mobile. Boost Mobile is owned by Dish Network. So you cannot go to AT&T and get some subpoena results for a phone that they do not belong to. I know this for a fact. I brought all this up to Mr. Hill. I pointed all this out to Mr. Hill. And I wanted to talk about the proper motions that should be filed in my case, but we have not been able to talk about that.
What motion you think should be filed in your case?
I feel like after we went through this discovery, and it has yet to mention me, first thing we do is a motion for suppressive evidence. There is no evidence against me. I went through everything with him.
But if there's no evidence, there's nothing to suppress.
So then I wanted to file for a motion dismissal. I feel like, and the reason why I want to file for the motion dismissal, Florida Rule 3.190, because for one, no evidence. Two, illegal search and seize, which I can prove because the phone is not in my name. I told the officers when they arrested me who phone it belonged to. I told Sergeant White when he came who phone belonged to. I told Mr. Hill who phone it belonged to, and I gave them her name. the whole step of the way. That is originally why I wanted the body cam footage, to prove that I was telling them that when they arrested me and when they said they had a search warrant for the phone. Come to find out, they never had a search warrant for the phone. They never was supposed to seize the phone and none of that. And that's why I was going for that illegal search and seize. But once I got my paperwork and it stated that Detective White got subpoena results from AT&T, I knew that was to be impossible because the phone does not belong to AT&T. The phone is not in my name. And I read the subpoena result with Mr. Hill, and he wrote to them, DMI Nazir Hadex is a customer, and they sent him results back. That could have never happened. Not only was I in prison.
What are you asking me to do?
I'm just trying to get some actual, I don't know what to do at this point in time. I went over my case. I'm ready to go to trial. I've been ready to go.
He doesn't know what to do at this time. Listen to your attorney. The attorney said exactly what you're saying at the beginning of this. Not in the roundabout way you're doing it, but he said he was filing the motion to suppress it. So what do you want? What more do you want to do? This guy's unbelievable. And then he's trying to say on the record that the body cam footage is irrelevant now. That's gonna come up in trial, and yeah, that's gonna be not gonna go well on you.
The trial since April 1st when I asked before I got my motion. I didn't need the motion. But now that I got it, I'm ready to go. If they want to go to trial, I'm ready to go to trial. But I know that for a fact, evidence was planted on me, and I can prove that. And I know that is illegal. I know that. And in this case, it shows it in black and white. Everything I'm going off, Your Honor, is just what's in here right here.
Do you think you should wait on the body cam footage from?
It's useless. It doesn't show anything besides me getting arrested and telling them that's Veronica Tellez's phone. Oh, we have a search warrant to go through it. Ooh. That's it. It shows the search of the house where they found nothing. Nothing was found.
Mr. Hadex, what? You have the right to a trial, and we'll make sure you get that trial. What I don't want to happen is you show up to trial, and Mr. Patterson, as the prosecutor comes forward, and he has a few witnesses from Georgia, the Georgia Bureau of Investigation and others, and you don't know what they're going to say. You don't know evidence they have because.
Answer, sir, please. Every time you open your pie hole, you get it worse trouble. So stay the course, will you?
Stand saying certain things that you're not prepared for, and then you object, or excuse me, Mr. Hill objects based on discovery violations. And I say, well, Mr. Hadex says he doesn't need that, didn't need that information, he didn't care about it. There's no evidence, so objection overruled. Have a seat. I don't want that to happen to you. I want the trial to be fair. You should know all the witnesses that the state may call against you. You should know beforehand all the evidence the state may use against you. You're entitled to that.
I am very well entitled to that. But I figured once my discovery was submitted to the clerk of courts, that was a finished discovery. Now I see if he was requesting the body cam footage for some. That's what we didn't talk about. I don't know why he requesting the body cam footage. All I know is why I asked for it previously, to prove the illegal search and seize. That's why I asked for it, and it was never brought up until we had that conversation, and I was able to point out to him this subpoena. Hold on, wait. I was in prison during this time. That's when our conversation was cut short. He wrote the date down when I got out. He wrote that down. He said he'd get back to me. Never got back to me. Now we come back to court. He said, all right, we're gonna file the motion for the body cam footage. I don't understand why I need the body cam footage. I don't understand nothing that the officers could say against me because they can't say nothing against me. All they did was arrest me, search my house, give a thumbs up, ask me, do I want to speak? I said no, and they took me to Bibb County Jail. That was it.
That's what you think they will testify to. If the state lists those officers as witnesses, Mr. Hill will have an opportunity to take their deposition. And then he will pin down exactly what they're going to say. I understand your position, Mr. Hadex, but what you do not want to happen is go to trial on some suppositions or beliefs of what you think police may say. And they come in here and take the stand and say something completely opposite of what you believe they're going to say. And you have no forewarning. And then you're jumping up and down in your seat. Crime foul. You don't want that to happen. Give Mr. Hill an opportunity. to obtain whatever evidence Georgia has. If it's nothing, it's nothing. Whatever witnesses in Georgia, give them the opportunity to speak with those witnesses. If they don't have anything to say against you, fine. They don't have anything to say. At least when you come to trial, at that time, Mr. Hill, if they take the stand and say something different, Mr. Hill can say, Judge, I took their deposition.
Oh, Mark, absolutely, absolutely, and it's about to get worse. I'm not going to say it's about to go down because it doesn't. There's no attitude in this. No one's yelling at each other. That's kind of what I reserved. It's about to go down for, but it's about to get so much worse for this guy, and he doesn't even know it. Sparkle Poots, all together now. Bless his heart. Thank you so much, Sparkle Poots. Jedi coming through. Stay with me, Meemaw. Bless his heart. Jedi Sparkle Poots, thank you so much for the super chats. I appreciate it.
Or he can impeach him with prior inconsistent statements, or if the state has evidence that they did not disclose and try to use against you at trial, that will be an issue. So allow Mr. Hill to do his job. He does it very well.
I know, I heard.
Yes, sir. Allow him opportunity to do his job. The issue with the subpoena and the dates, if that's true, I promise you there'll be a jury of 6 to 8 people over there, and Mr. Hill will bring that out during trial.
Okay, and another thing, the last thing me and Mr. Hill spoke on was my right.
Wixom, I will not. I will be in Michigan on Monday. This coming Monday. Oh, hold on. I'm verifying real quick. Where's that? Yeah, the 14th. I'll be there the 14th for Martin's trial. Wait, the 14th? Is that the 13th? I think I wrote down the wrong date. No, it is the 14th. Okay. I'll be there on Monday, so I'm not going to be there on what is that? That would be the Thursday. No. I'm not going to make 2 trips in 1 week. I'm going to go see Eric Martin get handled by Judge Shackelford on a bench trial.
To obtain that speedy trial without a demand, my 175 days is August 17th.
Okay. Mr. Hill knows exactly what to file if there's been a violation of your speedy trial rights. But right now, you just simply let me know what frustrations you have. Correct?
Correct.
Are you asking me to do anything specific?
I just feel like at this point, I don't know. Like, I don't really know who to talk to and what to talk to.
I have been checking every single day for a motion hearing before Monday because it doesn't make sense to me. Judge Shackelford skipped the whole final pretrial phase and went right to bench trial. Maybe the final pretrials for jury trials, I don't know. But it is still a bench trial scheduled on Monday. And I will check every single day to make sure that that's still going on. Because I keep waiting for it to get pushed back, and it hasn't. So unless it gets pushed back, I plan on being there.
At this point in time, I just know what I'm going off in my paperwork.
You have any type of disagreement with Mr. Hill?
We don't talk.
Well, you told me he's come out to see you in June.
The
He
first
may
time-
not talk to you as much as you would like, but he's talked to you.
When you-
One moment. Are you having some type of disagreement with Mr. Hill? Yes or no?
No.
Okay. So what's the next thing? Let Mr. Hill do his job. Mr. Patterson, have you talked to the law enforcement or probation officers in Georgia?
No, I have not spoken to officers in Georgia, but the sheriff's office investigator who worked this case has been in contact with GBI trying to get the copies that were requested by the defense in the motion.
Did they provide you with an estimated time they will receive them? That was them.
But I will follow up.
Just like Mr. Hadex was arrested December 4th of 2024.
I was arrested February 3rd, 2025.
Okay, I have that's your offense date. Mr. Hill?
Judge, I can tell the court without divulging too much right now. I have obviously met with Mr. Hadex. We have gone over his discovery. And what I have learned so far is there's quite a bit going on in this case, for one. What I know that's important right now is that a cell phone ended up in the custody of the Gulf County Sheriff's Office. The agent working this case has said that cell phone belonged to Mr. Hadex. It's Mr. Hadex's cell phone. It's my understanding that that cell phone was recovered by someone with either GBI or Georgia Department of Corrections probation office when they went in there and searched Mr. Hadex's house and arrested him on the warrant for Gulf County. How and where the phone was actually recovered from at the house, was it recovered from Mr. Hadex personally? Was it in the area where he was at? I don't have that information. I know that phone ended up in the custody of the Gulf County Sheriff's Office. And at that time, Sergeant White, the case agent, prepared and got a search warrant for that phone. I believe there are deficiencies with the search warrant for one, based on what I have read in the affidavit. And I have a tentative draft of a motion to suppress the search warrant for the phone. It's a tentative draft right now. There's a lot of different issues with the phone. The search warrant for the phone resulted in a Cellbrite report extraction report being provided, and Cellbrite data. I had reviewed that data, and on the data that we got off the Cellbrite, there is information there that I deem very incriminating in this case. So, it's very important that I have this information as to how and where the cell phone come from, so that I can complete this search warrant, the motion to suppress, and get it filed, because, I feel like a motion to suppress is going to be critical in this case at the right time to at least eliminating some potentially incriminating evidence against Mr. Hadex. If I can, it's one of the things, when I file the motion to suppress, I want it to be complete, and I want to file it one time, Judge. I already know there's at least some issues there to be addressed. There may be more issues out there to be addressed as far as how the phone was actually recovered. I hadn't got that far yet. But like I said, I don't know that a motion to suppress the phone would be dispositive of the case, because there is some other evidence out there, but it was certainly it's certainly going to hinder the prosecution's efforts, in my opinion, if evidence related to the phone search is ultimately suppressed. But like I said, it's not one of those cases where I've just been sitting back doing nothing. I have met with Mr. Hadex. There's obviously multiple cases on the docket, so we have multiple allegations. They're similar, but they're multiple cases. All the discovery is pretty much in one case. But like I said, we have a lot of, when you get, obviously the judge has been a prosecutor before, what these Cellbrite extraction reports, there tends to be a lot of data on these cell phones. It's not like something you can just sit down and spend 5 minutes looking through the data. There's photographs, there's text messages, there's videos and things of that nature on this cell phone that, as I said earlier, I deem it to be incriminating of Mr. Hadex in this case. So it's going to be important to address that through a motion to suppress at a later time. Like I said, if we it's just, I can't.
I got you. I know what you're saying. You're saying exactly what the defendant should do with everything he just said. Everything he's worried about, everything he believes, what you said is what he should do. So we're good, right? Nope, we're not.
I can only do so much with where we're at. And like I said, I've not scheduled depositions yet, because like I said, I may need to depose these people in Georgia when it gets down to it. But I don't want to schedule depositions until I know exactly who all the witnesses are.
Absolutely.
And I'm not trying to stall Mr. Hadex's case, but like I said, we've got all these cases and all these counts, and it's something that just takes a little bit of time to go through the nature of the evidence.
No, I agree.
And we've got stuff, and it's not only the stuff on the phone, Judge. I have gone over with Mr. Hadex video evidence that was obtained in other areas, other states besides Florida, that show Mr.
You don't need to say.
So,
anything.
I mean, so we've gone over the case,
All
none
right.
of the discoveries.
Mr. Hadex, well, first, we're not doing a Nelson hearing because you said there's no disagreement between you and Mr. Hill. You're not attempting to discharge him. It sounds like you just wanted some clarification about where things are. The cell phone in and of itself, you say it's not your cell phone, has nothing to do with you. With those Cellbrite reports, not only all the phone calls, the messages, but also the location data of the cell phone. I'm reading the complaint affidavit. The officer puts in here that the cell phone, well, he says is your cell phone, allegedly, places you in the location. It may not be right. It may not be your cell phone. It may not be true. But Mr. Hill, those Cellbrite reports, you can triangulate the towers to show exactly where that phone was. The individuals in Georgia are critical to that, whether it was your phone or not. If someone comes in this courtroom and said they took that phone out of your pocket and you want to take the stand and say it's not your phone, that's an issue. But if they found a phone in the basement in Georgia or in the backyard, and Mr. Hill takes their deposition and that's where they found it, then your defense may have some footing. Allow Mr. Hill to do his job. I promise you, not only have I been a defense attorney, a prosecutor, and sitting on the bench, Mr. Hill knows exactly what he's doing. He is very competent. Trust him.
I can't, because he just said something that was false.
Okay, what we'll do, we'll come back on Thursday. We'll have a Nelson hearing. We'll come back on Thursday. We'll have a Nelson hearing. I'll place you on the oath. You can tell me what's going on, and I'll hear Mr. Hill's response.
No, why do I feel so bad for this guy? I don't know. He doesn't want a Nelson hearing. He doesn't understand what's going on. Not at all. Not at all. But good news is we'll get a Nelson hearing on Thursday. Oh, I can't believe this guy. Anyways, that's it. That's the show, guys. I appreciate you guys hanging up. Appreciate you hanging up. It's not what I meant to say. I appreciate you guys hanging out. There we go. Cheshire Cat, thank you so much for the super chat. And yeah, don't forget to take your meds. Meds are good. They're good. Take them. They're good. They help. Cheshire Cat, hopefully your hand gets better. Kimberly Smith, thank you so much. Late to the party fee. I appreciate the super chat. Thank you so much. And Vic sent I think it was a Venmo for gas money for Monday. Thank you so much, Vic. I appreciate it. Thank you so much. Very generous of you. All right. That's all I got, guys. I've got my video for tomorrow that I'm releasing is going to be a lot of fun. I've got it's actually pains me to say this out loud. I've got someone who doesn't like the Jewish people too much decided to do something really bad, and then he goes pro se in court. So I have that video for tomorrow, and then just because we're sticking to religion, I've got a guy that told the judge that he's pro se because the Bible says attorneys are awful. The judge called him out on it and just said, where in the Bible does it say that? He went and got a Bible. And when he couldn't find it, he started crying. I can't find it. It's like, oh my gosh. Yeah, so I'm putting those two videos in two clips or cases in one video tomorrow. It's going to be interesting. I'm kind of afraid of what the comment section is going to look like on that video, but yeah, it's going to be a wild one. Anyways, thank you guys so much for hanging out with me tonight. I appreciate it. Biggin, I doubt you're still here, but thank you so much for the raid. Everyone that came over from Biggin, thank you so much. All the super chats, gifted membership milestones. You guys are awesome. Yeah, he was absolutely crying. He couldn't find the Bible verse, and he started telling the judge his entire life story. It completely changed. I thought we were going to get, only God can judge me, and I did not expect the twist where he went full man baby mode. Who are we rating tonight? We're gonna head over to Lone Wolf. I already got that set up. So thank you guys so much. I appreciate it. I will see you tomorrow night. Check out that video tomorrow. Be kind in the comments. If you see people saying dumb things in the comments, make sure to tell them that don't do that. We're gonna make the video. Well, I'm gonna make the video, and hopefully it doesn't get shut down. I'm a little worried about it. I don't usually touch the religion topic, and it's not really the religion topic. It's just one guy is clearly he's very anti-Jewish people, and then the other guy, he's a devout Christian. It's what they are. Anyways, it'll be fun. All right, have a great night. I'll see you all tomorrow. Say hi to Lone Wolf for me, and yeah, that's it. That's all I got. Bye.